Hello, everyone. Thank you for tuning in to today's webinar. My name is Caleb Tingstad. I am a lawyer at the firm Beresford Booth here in Edmonds, Washington. And my practice is primarily a transactional practice. But the litigation that I generally participate in is business divorce litigation, which I really enjoy because there's a lot of practical transactional sides to it. And in my experience, as well as the experience of some of my colleagues, there's a lot of do's and don'ts that we find just throughout the various business divorce matters that we have had. And so I wanted to take a couple of minutes today and just speak about some of the general rules, the do's and the don'ts, if you will. Knowing that in the legal industry, finding things that are absolutes is nearly impossible. And I still think this is one of those cases, every single dispute is unique, every single business is unique, every transaction is unique. And so everything still needs to be treated on a case-by-case basis. But when individuals find themselves in disputes with their business owners, their partners, there are some general rules we think that are helpful, principles that can be helpful in guiding the conduct between the start of the dispute and actually engaging a lawyer. So the first thing we'll do is actually talk about what in the world of business divorce is. And so we call it a business divorce because it's kind of like when business owners split up, it's kind of like a divorce between a husband and a wife. There's a bunch of assets that presumably need to be split up. There's some claims. There's more often than not claims that someone has done something wrong, violating an operating agreement, breaching fiduciary duties, these types of things. And we colloquially refer to those types of disputes among co-business owners as business divorce. And with that in mind, we have some practice do's and don'ts. We'll start with the do's here. I always have a conversation with my clients from the outset that you have an obligation always to be the good guy. As soon as the dispute arises and there's any kind of likelihood of litigation, the parties are going to be splitting up. I always want to represent the good guy, and if you're a business owner in a dispute with your co-owner, you also want to be the good guy. There's the law with these types of things, and judges are expected to apply the law. But as much as judges will try and apply the law, they also want to make sure that they're ruling in favor of the good guy. And so that's holding yourself in a high manner, being honest with your co-owner, other employees of the business about what's going on. That's very important when you're talking about a business divorce. Also, you should be very conscious of the status quo and wary of it, and particularly you want to make sure. In most instances, my recommendations to clients is that you do your best to preserve the status quo. When the status quo gets shaken up, things can change very, very quickly. And in litigation, the avenues that we have to deal with changes to the status quo, including motions for temporary restraining orders or preliminary injunctions, those tend to be very, very expensive endeavors that are not to be trifled with lightly. And so for individuals that find themselves in disputes with their co-owners, you should at least between the time that the dispute arises and speaking with counsel, you should absolutely do your best to maintain the status quo. Don't rock the boat. I also tell my clients to exercise their contractual and legal rights. If you've got an operating agreement, your operating agreement gives you certain rights. It's still appropriate to exercise those rights. If you have, rights that are set forth under Washington's LLC statute or the corporate statute or the partnership statute, it's entirely appropriate to exercise those rights. But you definitely should do so carefully. And this is, where counsel comes in and is able to provide an independent and sound analysis of whether it's in the client's best interest to exercise those contractual and legal rights. A lot of times, operating agreements will have mandatory indemnification provisions. Sometimes in a business divorce matter, even though there is a contractual right to indemnification, it may not be in the best interest of the parties to go and exercise that right. Sometimes it is, but being aware of the rights that you have both contractually and legally, and exercising them I find is generally appropriate, but you definitely need to do so carefully. And finally, the practical aspect of these of business divorce cases is not lost on us. There's it's the business is kind of like the kid that's stuck in the middle of the parents' divorce, and unfortunately, sometimes the business can get neglected or forgotten in the midst of these disputes. And so, I always try and tell my clients that they should continue to do their best to keep the business going, because with a lot of these types of disputes, our clients have invested tons and tons of their time and money into building the successful business. And if you let the dispute take you away from the business and keeping it going, all of a sudden it becomes a lot easier to lose everything that you have. And so trying to strike that balance of navigating the dispute while keeping the business running is, I certainly think, one of the ways that our firm separates ourselves from other lawyers who potentially litigate business divorce cases. We're always trying to keep in mind the practical aspect of the dispute, in addition to the legal side. This takes us into our don'ts. The first don't on here is appoint yourself king or queen. A lot of times, particularly when you're dealing with two co-owners, you're going to have an individual who is more likely to try and freeze the other one out, basically appoint themselves as the king or queen, and the king or queen of the business, and is not willing to consider the other partner and their rights. And this is kind of getting back to what we talked about earlier of exercising your legal and contractual rights carefully, because sometimes even if you have the right to do something like this, even from an optics perspective, it may not necessarily be the best course of action. So certainly, when you are a business owner and you find yourself in a dispute with your co-owner, my recommendation is, to try and continue to be as cooperative as you can, and don't do drastic things such as appointing yourself, the arbiter of truth itself in the context of your dispute, or at least certainly don't do that without consulting counsel. The second thing I always tell my clients, and this kind of calls back to being the good guy, don't disparage your partner. It's never good. Those kind of communications always come out in the legal process. There is discovery. That one time that you called your co-owner a horrible name in that text message to your friend about how frustrating this is going to come out, and judges don't particularly like that sort of a thing. It doesn't make you look like the good guy. And so, always want to be conscious of the content of the messages that you're sending, both verbal and otherwise. Emails, text, it's all subject to discovery if a dispute turns into litigation. And so my recommendation to all my clients is to make sure that you're not out there saying mean things about your partner, even if it's true. do do not do not take the bait. Do not disparage your partner. And finally, this, and kind of calling back to some of our do's earlier, don't change the status quo unless you're ready to confront the consequences. Speaking a little bit earlier about temporary restraining orders and preliminary injunctions, those have significant consequences and can frequently bring the dispute to a court decision very early on in the case. In those types of hearings, courts are required to decide who has a likelihood of success on the merits. And unless you're comfortable with the risk that a case may proceed throughout its entirety with a court ruling who, on a preliminary basis, they believe is likely to succeed, that comes with it a lot of risk. And changing the status quo is what is going to trigger that kind of a hearing very early on in business divorce litigation. And so, I always tell my clients, keep the status quo for as long as you can, unless you're prepared, to deal with what happens when that status quo changes. This is, that kind of wraps up what we're talking about today in terms of the do's and don'ts of business divorce. I've got a little QR code here. If you have your phone, you can go ahead and scan it. My electronic card will pull up. Once again, my name is Caleb Tingstad from Beresford Booth, and feel free to reach out to me if you have any questions or thoughts, and we look forward to working with you in the future.